all of that that's in there is about whether or not, it is about the cases where a court has to assess whether or not an agency has an authority to do something. The agency itself, when arguing that, may bring in as many experts as they like to say that this is that and this is that and all this other kind of stuff. That doesn't change the legal question. In the US, there's always been something of an interesting and sometimes tense relationship between scientific expertise, scientific research, and the law. And for those of you who've been paying attention, you probably noticed a particular decision from the Supreme Court. Not one that is probably particularly in the news as of the time of this recording, because I know there were others that have come out since the particular ruling I'm interested in. But there's been a lot of hyperbole around the particular decision, which involves abandoning something called the Chevron doctrine in law. And basically, it involves, well, the role of scientific expertise in U.S. rulemaking. And I do think, having seen some of the hyperbole with this, that it's overblown. Some takes I've seen online have basically been arguing, well, this decision means that ultimately scientific grants are going to be ended and all this. Way overblown. I'm sorry. That is way, 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 way overblown. Those kind of hot takes I've noticed. Because I read the recent decision that overturned Chevron, and that's not the interpretation I get from it. It actually has nothing to do with the scientific side as much as a question of law. And I've talked about this ad nauseum with previous decisions where there was a similar kind of thing. I think it was last year, there were a couple of decisions where it was like simultaneously Nature, Science, and Scientific American all came out with this thing of the Supreme Court is anti-science. Stupid. Very stupid. And we're going to get back into that again, talking about this particular case, because of course it's come up in science. Supreme Court ruling may threaten role of science in U.S. rulemaking. Decision to abandon Chevron doctrine could have far-reaching implications for government programs. Now, the Chevron doctrine, I want to just go over here and show some of this, because the general syllabus with what's called the Chevron doctrine comes from a case called Chevron USA Inc. versus the NRDC. In here, and it had to do with the Clean Air Act at the time that had been amended, and what it was basically was the idea that when when Congress makes a law that is supposedly, well, not is supposedly, but is ambiguous, then the courts have to give deference to the agency that is acting under that law to make a rule or a regulation. That was the ruling of Chevron. And where it is interesting, and the reason it became a problem, might have had something to do with, well, some of the particular things about it. So, in the particular case of Chevron at the time, it had to do with what counted as a stationary source in the law, according to the Clean Air Act, with respect to plants and things like that. So, but one of the things here that made it an interesting issue was the plant-wide definition is fully consistent with the policy of allowing reasonable economic growth, and the EPA has advanced a reasonable explanation for its conclusion, and the regulations serve environmental objectives as well. The fact that EPA has from time to time changed its interpretation of the term source does not lead to the conclusion that no deference should be accorded the EPA's interpretation of the statute. An agency to engage in informed rulemaking must consider varying interpretations and the wisdom of its policy on a continuing basis. Policy arguments concerning the bubble concept should address to legislators or administrators, not to judges. The EPA's interpretation of the statute here represents a reasonable accommodation of manifestly competing interests and is entitled to deference. So that's a lot of what that had to do with, is basically the Chevron doctrine 1984 case basically set the standard of, courts should defer to agency expertise as per the interpretation of a statute that is ambiguous from Congress. that was the question at hand here, not because of the statute itself, but in interpretation. Well, how broad of an interpretation ends up being reasonable is the question that results from that. This is from Science. In a much anticipated decision that many scientific groups had feared, the U.S. Supreme Court today, this is not today as of the time of this recording, but is June 28th, 2024, the U.S. Supreme Court overturned a 40-year-old doctrine that gave federal agencies considerable leeway in interpreting laws passed by Congress. The 6-3 ruling means judges should no longer defer to the scientific expertise of those agencies on a vast range of technical questions, and instead should make such decisions themselves. I disagree with that interpretation from Science at this point. Agencies have no special competence in resolving statutory ambiguities. Courts do, Chief Justice John Roberts said in the majority opinion in Law for Bright Enterprises versus Raimondo, a case involving environmental regulations affecting herring boats. Groups who urge the High Court to retain the so-called Chevron doctrine are worried the nation's courts may not be equipped to take on that job. The ruling, quote, will thrust federal agencies' decision-making into uncharted waters and fundamentally change the way scientific information is used in federal policymaking. Now, this is actually from the CEO of the American Association of the Advancement of Sciences, which publishes the same journal, Science. The ruling also discounts the value of scientific expertise, says George Washington law professor Emily Hammond. Quote, the idea that generalist judges are now best situated to make those kinds of decisions as compared with scientists, engineers, and technical experts at those agencies really flips on its head decades of expectations about the relative competencies of agencies versus judges. But many conservatives, including leading Republicans in Congress, hailed the ruling. Today's decision fixes the decades-long error of handing vague and broad powers to unelected and unaccountable bureaucrats, said Representative Jim Jordan, part of a group of Republicans in the House of Representatives, who asked the justices to end the Chevron deference policy. The doctrine was formulated in the High Court's 1984 ruling Chevron USA Inc. versus the Natural Resources Defense Council, the NRDC, a dispute over how the U.S. Environmental Protection Agency had interpreted a provision of the Clean Air Act regulating power plants. Although environmental groups lost their argument that then President Reagan's administration's interpretation of the law favored industry, the court's decision laid out a two-step process for deciding how federal courts should mediate such disputes. Courts have had no cause to intervene if Congress has been clear about its intent, the High Court explained, but if there are ambiguities or gaps in the law, they added, courts should defer to the agency's interpretation if the agency's actions are reasonable and based on compelling evidence. Reasonable and based upon compelling evidence. This is where it gets very interesting with it, because how do you define reasonable in this is the question. Reasonable has to be addressed not necessarily in the scientific realm, but in the legal realm with it. And that is why I disagree about some of the assertions there, because the compelling evidence part may still well be there. The reasonableness part has to come back to something in law, i.e., is this perhaps something that would make the agency be doing something that is not under the mandate of that agency to begin with, i.e. Congress never authorized that agency to do that. And the other aspect of this is, well, is it exceeding current authority to do that in the slightest too? And those are two very much the same thing. But that's very different from scientific expertise being come into question about a rule that an agency wants to promulgate, wants to use. That approach has since been applied in thousands of cases, including the Chevron approach, that is, involving government regulations affecting businesses, schools, and the general population. However, today's ruling, June 28th again, says it must be discarded because it conflicts with a 1946 law called the Administrative Procedure Act that makes the judiciary, not the executive branch, the final arbiter of nearly all disputes over federal statutes. Roberts also called the Chevron doctrine fundamentally misguided and unworkable. I agree to a certain degree with that, in the sense that Reasonable is the questioning it. What is a reasonable interpretation the agency can make of its own statute? And what is to stop an agency from seizing more power for themselves by a supposedly reasonable interpretation? None of that, question-wise, is actually about science. As much as there's freaking out here that scientific expertise in rulemaking is being undermined, that's not what it is. You can still have very much information provided to a judge about the outside expertise. In fact, Matter Science goes on to admit that. Today's ruling still leaves room for judges to tap into outside expertise, legal experts say, but some say it is that as a poor substitute. The courts assume they can get technical expertise to some degree from agencies, but also from amicus briefs. But it's pretty tough for me to see how that will work in practice. Yeah. But here is the thing with that. None of this about the authority of an agency to do something necessarily has anything to do with scientific expertise. You can say, very much so, okay, scientific thing, our thing is this. There's still a question then. Scientific expertise says this is a water body in the United States. This is a plant that is a stationary source. All of those kinds of things. That doesn't necessarily answer the question of whether or not it's reasonable, which is to say, in this case, reasonable being, does it exceed the authority assigned to the agency by Congress? And that is a matter of legal interpretation. That is not a matter of scientific expertise in the slightest. Those are two very different things. People tend to forget that there are different things that science and law work in necessary things here. And so that's the reason I point this out. This is the Chevron decision. I'm sorry, not the Chevron decision. This is the Lauper decision itself as it relates. But I also want to point out, yes, this one. This is a little bit hyperbolic, but it did have something to do with exactly what was going on. In decent summary, what was going on with the Lauper decision and what happened with Chevron deference. And so, for those who don't understand, here's the long and short of it. A family fishing company, Lauper Bright Enterprises, was being driven out of business because they couldn't afford the $700 per day they were being charged by the National Marine Fisheries Service to monitor their company. The thing is, federal law doesn't authorize the National Marine Fisheries Service, the NMFS, to charge businesses for this. They decided to start doing it in 2013. Why did they think they could get away with just charging people without any legal authorization? This is the point that I want to make. And again, this is somewhat hyperbolic, but here's an example that I want to make with that. It might be there in the scientific thing that they need to monitor these fish, and they need to have things there to monitor those fish. That doesn't necessarily mean that that particular agency has the right or the authority to charge other people for it. Those are two very different questions. One of them does involve scientific expertise, one of them does not. And this is actually where you get into some of the interesting questions. So, this is the Lauper decision itself. And I would love to hear more from the legal folks out there, but I tend to take very different thinking about what is a matter of a judge to resolve, which is statutory ambiguities. It is the job of the judiciary to interpret law when there's particularly disputes involved. It is not the job of the agency to do that. It is the job of the agency to be following the law, to be executing upon the law. And that is where the reasonable interpretation thing comes back in. Are you interpreting the statute in a way that it was not granted to you by Congress to do? And I do agree that actually Congress has produced a lot of ambiguous laws and try to figure out how to, shall we say, execute upon them. I'll just read from the syllabus for this. There's more in here. As always, these things are huge. You guys can't see the page numbers up here, but this is a 114-page decision. I'm not going to read through all of it right now. Those kinds of things. But allow me to show you. The court granted certiorari in these cases limited to the question of whether Chevron v. NRDC should be overruled or clarified. Under the Chevron doctrine, courts have sometimes been required to defer to permissible, this is the other question, what the heck is permissible? Agency interpretations of those statutes, of the statutes those agencies administer, even when a reviewing court reads the statute differently. This is a point to be made. If the court disagrees with the agency's interpretation of the statute, whatever the scientific experience that's involved, the scientific expertise and experience that's involved, that's still a legal question. And the courts have the authority over the interpretation of the statute under the Constitution, not necessarily the particular agency, but it's the courts who have that ultimate authority in interpretation of the laws passed by Congress. It is, of course, Congress that writes the laws that gives the authority to these particular agencies. Let's see. In each case below, the reviewing courts applied Chevron's framework to resolve in favor of the government challenges by petitioners to a rule promulgated by the National Marine Fisheries Service pursuant to the Magnuson-Stevens Act, which incorporates the Administrative Procedures Act. So, 1946, the Administrative Procedures Act, it set out a whole bunch of rules for how any agency is to go about rulemaking, is the answer with that. The Administrative Procedure Act requires courts to exercise their independent judgment when deciding whether an agency has acted within its statutory authority. And courts may not defer to agency interpretation of the law simply because a statute is ambiguous. Chevron is overruled. You realize this is about statutory ambiguities in this. This is about the interpretation and whether or not an agency is overstepping its authority. Not necessarily about any of the science involved. This could actually be very much applied to anything. That doesn't mean you can't have scientific expertise involved. You can have perfectly good scientific expertise. The different agencies could be sending their experts to the court to say, here's the scientific basis for this rule we want to do, and then they can have the legal argument via their lawyers versus the other plaintiffs' lawyers of this is how it falls in line with the statute, how we think it falls in line with the statute, and then the court exercises its own judgment. Natural judicial review, actually. Both of those sides, though, could end up operating on the same premise of scientific expertise to say, yeah, we agree, it's this. But you may very well have a situation, you can say, we agree the scientific aspect is this, but you may very well have an interpretation of whether or not the action based upon that scientific expertise is legal and falls within the authority of the agency. Those are two different questions. Two very, very different questions. And I, for one, personally would like to see the power of the executive diminished, not increased. And that's where I think I've had a problem with Chevron as I've read it, is it gave too much deference to the executive. To the executive branch, which includes all the agencies under the president. Article 3 of the Constitution assigns to the federal judiciary the responsibility and power to adjudicate cases and controversies, concrete disputes with consequences for the parties involved. The framers appreciated that the laws judges would necessarily apply in resolving those disputes would not always be clear, but envisioned that the final interpretation of laws would be the proper and peculiar province of the courts. Federalist 78. As Chief Justice Marshall declared in the foundational decision of Marbury v. Madison, it is emphatically the province and duty of the judicial department to say what the law is. In the decades following Marbury, when the meaning of a statute was at issue, the judicial role was to interpret the act of Congress in order to ascertain the rights of the parties. The court recognized from the outset, though, that exercising independent judgment often included according due respect to executive branch interpretations of federal statutes, interpretation of the statute. Such respect was thought especially warranted when an executive branch interpretation was issued roughly contemporaneously with enactment of the statute and remained consistent over time. The court also gave the most respectful consideration to the executive branch interpretation simply because the officers concerned were usually able men and masters of the subject, who may well have drafted the laws at issue, United States versus Moore. Respect, though, was just that. The views of the executive branch could inform the judgment of the judiciary, but not supersede it. but did not supersede it. And this is the views of the executive branch. This is not just the scientific views that we're talking about. We're talking about the legal interpretations, too, because when executive branch lawyers come into this in a dispute, arguing against somebody else, they're going to have their own interpretation of the statute. And it is up to the court to decide who's correct in the dispute. Again, the reason I'm harping on this is none of this is scientific. None of this actually has all that much to do with scientific expertise. In cases where a court's own judgment differed from that of other high functionaries, the court was not at liberty to surrender or waive it. In other words, you're not at liberty to waive your obligation to interpret the law. During the rapid expansion of the administrative process that took place during the New Deal era, United States versus Morton Salt, the court often treated agency determinations of fact as binding on the courts, provided that there was evidence to support the findings. But the court did not extend similar deference to agency resolutions of questions of law. I want to make a point here in that there's two different things. Determinations of fact and evidence to support its finding, providing that there's evidence to support the finding, is different from questions of law. Where the scientific side ends up coming in is actually in these determinations of fact, but also as evidence to support the findings. It doesn't necessarily come in with questions of law. The interpretation of the meaning of statutes as applied to justicable controversies remained exclusively a judicial function. United States versus American Trucking Associations. The court also continued to note that an informed judgment of the executive branch could be entitled to great weight. The weight of such a judgment in a particular case, the court observed, would depend upon the thoroughness evident in its consideration, the validity of its reasoning, two things, and its consistency with earlier and later pronouncements, and all those factors which give it power to persuade, if lacking power to control. Occasionally during this period, the court applied deferential review after concluding that a particular statute empowered an agency to decide how a broad statutory term applied to specific facts found by the agency. But such deferential review, which the court was far from consistent in applying, was cabined to fact-bound determinations. This is the thing. To fact-bound determinations in this. It's not, which is to say, if you're going to have a particular scientific thing here that is very well known, that's a fact-bound determination. And the court did not purport to refashion the long-standing judicial approach to questions of law. It instead proclaimed that undoubtedly questions of statutory interpretation are for the courts to resolve, giving appropriate weight to the judgment of those whose special duty is to administer the questioned statute. Nothing in the New Deal era or before thus resembled the deference rule the court would begin applying in decades later to all varieties of agency interpretations of statutes under Chevron. Congress in 1946 enacted the APA, Administrative Procedure Act, as a check upon administrators whose zeal might otherwise have carried them to excesses not contemplated in legislation creating their offices. That is one of the reasons that APA came about. It was basically to curb rulemaking a fair bit, so that the executive didn't necessarily exceed its authority. What they basically go on to say here is this is quite long, so that's why I'm not necessarily going to read absolutely everything, but I encourage you to go read it and think for yourself about it. To be honest, that's part of what this is about, is just reading some of these things and getting some knowledge and learning a bit about it. The deference that Chevron requires of courts reviewing agency action cannot be shared with the APA. Chevron, decided in 1984 by a bare quorum of 6 justices, triggered a marked departure from the traditional judicial approach of independently examining each statute to determine its meaning. The question in the case was whether the Environmental Protection Agency, EPA, regulation was consistent with the term stationary source as used in the Clean Air Act. To answer that question, the court articulated and employed a now familiar two-step approach broadly applicable to review of agency action. The first step was to discern, quote, whether Congress had directly spoken to the precise question at issue. The court explained that if the intent of Congress is clear, that is the end of the matter, and courts were therefore to reject administrative constructions which are contrary to clear congressional intent. But in a case in which the statute was silent or ambiguous with respect to the specific issue at hand, a reviewing court could not simply impose its own construction on the statute, as would be necessary in the absence of an administrative interpretation. Instead, at Chevron's second step, a court had to defer to the agency if it had offered a permissible construction of the statute. Again, permissible construction of the statute still goes to the legal interpretation of the agency, not necessarily the scientific information that's behind it, behind what the agency wants to do. The legal interpretation is what matters in that. Even if not the reading the court would have reached if the question initially had arisen in a judicial proceeding. Employing this new test, the court concluded that Congress had not addressed the question at issue with the necessary level of specificity, and that the EPA's interpretation was entitled to deference. Although the court did not at first treat Chevron as the watershed decision it was fated to become, the court and the courts of appeals were soon routinely invoking its framework as the governing standard in cases involving statutory questions of agency authority. This is exactly what it's about. It's not necessarily the scientific expertise that's involved, not necessarily attacking the scientific expertise at all. It's a question of whether or not an agency has the authority to do the thing for which it has solicited scientific expertise to do. That is two very different questions. And that's why I take issue with the notion that you're just attacking scientific expertise in rulemaking. That's not necessarily the case. You could actually have two different groups come to the same agreement on what the scientific expertise says and agree that, yeah, this is necessary to do that. But we also disagree of whether or not the agency actually has the authority to do that action. Two very, very different things. And they should not ever be confused with each other. The court eventually decided that Chevron rested on a presumption that Congress, when it left ambiguity in the statute meant for implementation by an agency, understood that the ambiguity would be resolved first and foremost by the agency, and desired the agency to possess whatever degree of discretion the ambiguity allows. Neither Chevron nor any subsequent decision of the court attempted to reconcile its framework with the APA. Chevron defies the command of the APA that the reviewing court, not the agency whose action it reviews, is to decide all relevant questions of law and interpret statutory provisions. It requires a court to ignore, not follow, the reading the court would have reached had it exercised its independent judgment as required by the APA. Chevron insists on more than the respect historically given to executive branch interpretations. It demands that the court mechanically afford binding deference to agency interpretations, including those that have been inconsistent over time. And even when a pre-existing judicial precedent holds that an ambiguous statute means something else. That regime is the antithesis of the time-honored approach the APA prescribed. Chevron cannot be reconciled with the APA by presuming that statutory ambiguities are implicit delegations to agencies. That presumption does not approximate reality. A statutory ambiguity does not necessarily reflect a congressional intent that an agency, as opposed to a court, resolve the resulting interpretive question. Many or perhaps most statutory ambiguities may be unintentional, and when courts confront statutory ambiguities in cases that do not involve agency interpretations or delegations of authority, they are not somehow relieved of their obligation to independently interpret the statutes. Instead of declaring a particular party's reading permissible, in such a case, courts use every tool at their disposal to determine the best reading of the statute and resolve the ambiguity. But in an agency case, as in any other, there is a best reading all the same, the reading the court would have reached if no agency were involved. This is actually a note of consistency on these things. What they're talking about here is you probably should have the court's role be the same regardless of whether or not an agency is involved with respect to resolving statutory ambiguities. That's actually pretty consistent to me, if you ask me. Again, doesn't necessarily involve scientific expertise in this, because again, everybody could agree. The science says X about this, or scientific studies say X about this, so agency may argue we're going to do this rule. somebody else may say you're overstepping your authority. That takes it from a scientific question to being about the legal authority of an agency. Two different things. It is okay. It therefore makes no sense to speak of permissible interpretation that is not the one the court, after applying all relative interpretive tools, concludes is best. Perhaps most fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. The framers anticipated that the courts would often confront statutory ambiguities and expected that the courts would resolve them by exercising independent legal judgment. Chevron gravely erred in concluding that the inquiry is fundamentally different just because an administrative interpretation is in play. This is an important thing. Equal application, equal approaches to things. Whether or not an agency is involved, the court should still be engaging in the interpretation independently, respecting that an agency has its opinion on the issue, but doing their own interpretation independent of whatever parties are involved. The very point of the traditional tools of statutory construction is to resolve statutory ambiguities. That is no less true when the ambiguity is about the scope of an agency's own power, perhaps the occasion on which abdication in favor of the agency is least appropriate. Yes, if the court is resolving something having to do with an agency's power, it's not appropriate for them to defer to the agency. The government responds that Congress must generally intend for agencies to resolve statutory ambiguities because agencies have subject matter expertise regarding the statutes they administer. Because deferring to agencies purportedly promotes the uniform construction of federal law, and because resolving statutory ambiguities can involve policymaking best left to political actors rather than the courts. But none of these considerations justify Chevron's sweeping presumption of congressional intent. As the court recently noted, interpretive issues arising in connection with a regulatory scheme may fall more naturally into a judge's bailiwick than an agency's. Under Chevron's broad rule of deference, though, ambiguities of all stripes trigger deference, even in cases having little to do with an agency's technical subject matter expertise. This is actually one of the things I was pointing to. And even when an ambiguity happens to implicate a technical matter, it does not follow that Congress has taken the power to authoritatively interpret the statute from the courts and given it to the agency. Congress expects the courts to handle technical statutory questions, and courts did so without issue in agency cases before Chevron. After all, in an agency case in particular, the reviewing court will go about its task with the agency's body of experience and informed judgment, among other information at its disposal. An agency's interpretation of the statute cannot bind a court, but may be especially informative to the extent it rests on factual premises within the agency's expertise. Delegating ultimate interpretive authority to agencies is simply not necessary to ensure the resolution of statutory ambiguities and is well informed by subject matter expertise. Nor does a desire for uniform construction of federal law justify Chevron. It is unclear how much the Chevron doctrine as a whole actually promotes such uniformity. And in any event, we see no reason to presume that Congress prefers uniformity for uniformity's sake over the correct interpretation of the laws it enacts. Finally, the view that interpretation of ambiguous statutory provisions amounts to policymaking suited for political actors rather than the courts is especially mistaken because it rests on the profound misconception of the judicial role. Resolution of statutory ambiguities involves legal interpretation, and that task does not suddenly become policymaking just because a court has an agency to fall back on. Courts interpret statutes, no matter the context, based on the traditional tools of statutory construction, not individual policy preferences. To stay out of discretionary policymaking left to the political branches, judges need only fulfill their obligations under the APA to independently identify and respect such delegations of authority, police the outer statutory boundaries of those delegations, and ensure the agencies exercise their discretion consistent with the APA. By forcing the courts instead pretend that ambiguities are necessarily delegations, Chevron prevents judges from judging. And that is the point here with a lot of this. Again, I won't go too much further in this particular case, but they came down here to the ending here, and this is actually the final couple paragraphs are actually pretty interesting themselves. Chevron has proven to be fundamentally misguided. It reshaped judicial review of agency action without grappling with the APA, the statute that lays out how such review works. Its flaws were apparent from the start, prompting the court to revise its foundations and continually limit its application. Experience has also shown that Chevron is unworkable. The defining feature of its framework is the identification of statutory ambiguity, but the concept of ambiguity has always evaded meaningful definition. Such an impressionistic and malleable concept cannot stand as an everyday test for allocating interpretive authority between courts and agencies. The courts has also been forced to clarify the doctrine again and again, only adding to Chevron's unworkability, and the doctrine continues to spawn difficult threshold questions that promise to further complicate the inquiry should Chevron be retained. And its continuing import is far from clear, as courts have often declined to engage with the doctrine, saying it makes no difference. Nor has Chevron fostered meaningful reliance. Given the court's constant tinkering with an eventual turn away from Chevron, it is hard to see how anyone could reasonably expect a court to rely on Chevron in any particular case or expect it to produce readily foreseeable outcomes. And rather than safeguarding reliance interests, Chevron affirmatively destroys them by allowing agencies to change course, even when Congress has not given them the power to do so. Even when Congress has given them no power to do so. The only way to ensure that law will not merely change erratically, but will develop in a principled and intelligible fashion, is for the court to leave Chevron behind. By overruling Chevron, though, the court does not call into question prior cases that relied on the Chevron framework. This is important to recognize, which means to say we're not going to overturn anything else. Anything that was made with that old doctrine stands. The holdings of those cases that specific agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis despite the court's change in interpretive methodology. Mere reliance on Chevron cannot constitute a special justification for overruling such a holding. Okay. All of that that's in there is about whether or not, it is about the cases where a court has to assess whether or not an agency has an authority to do something. The agency itself, when arguing that, may bring in as many experts as they like to say that this is that and this is that and all this other kind of stuff. That doesn't change the legal question. All the scientific expertise in the world doesn't change the legal question of whether or not an agency has the authority to do what it's doing via that rule. That is the province of the courts. And this is where I again repeat what I have said ad nauseum before. Last year, when lots of Supreme Court cases came out, I think I did this the year before, there is a very big difference between science and legal related stuff. The questions answered by the Supreme Court are legal related questions. The questions that might be used to inform a rule that gets challenged are scientific related questions. Those are two very different things. Just because you have scientific expertise and parties involved could agree that the scientific expertise in here is valid and points toward this particular thing that we probably should do monitoring for, or should do this, or should do that, or should regulate it this way, or what have you. That does not mean the agency has the authority to do that. And the determination of whether or not an agency has the authority to do that is exclusively the domain of the courts interpreting Congress. It is interpreting the laws passed by Congress. It is not the domain of the scientific agencies, the scientific expertise within agencies. Those are two very different things. So I don't necessarily hold that this is going to do anything to cause any problems for science and rulemaking, which seem to be the hyperbolic connotation of a lot of things. But it is probably going to make it more difficult for certain agencies to pass rules. And frankly, for me personally, in my opinion, I prefer that myself. I don't prefer a federal government that has a tremendous amount of power. I prefer a federal government that has a bit less. myself, but that's my opinion. Let me know what you think. Hit the like button on the way out the door, comment on the video, share the video, subscribe to the channel, all that lovely good jazz. Apologies for it being such a long video. Till next time, I'm Adrian. May you stay curious, everybody.